Welcome back, everyone, to another deep dive. Today, we're going to be exploring the world of tort law, drawing on the fascinating material you've sent our way. I think it's safe to say tort law is something that impacts all of us, maybe without us even realizing it. But after this deep dive, I guarantee you'll start seeing tort lurking everywhere.
Absolutely. It's like that hidden network of rules that governs how we interact with each other, on a day-to-day basis.
Exactly. So our mission today is to untangle this web of legal principles, pull out the really crucial insights, and try and leave you with a clear grasp of how this all works in the real world.
Sounds good to me. I think one of the first things to clarify is, what exactly is tort law? Because it's not always immediately obvious, is it?
No, it's not. To me, it always sounded a bit like, well, a bit like a French pastry, to be honest.
Right, right. But actually, it's all about civil wrongs. Think of it as the legal system that steps in when someone's rights have been violated, outside of the criminal realm. It's that mechanism for righting wrongs and holding people accountable when they cause harm to others.
Okay, so it's not about punishing people like in criminal law. It's about providing remedies for those who have been harmed. And from the looks of it, the most common type of tort we're dealing with is negligence.
Right. Absolutely. Negligence is the big one. It's not about someone intentionally causing harm, but more about, well, carelessness. When someone doesn't act as a reasonable person would, and that carelessness ends up causing damage or injury to another person.
Okay, carelessness leading to harm. Got it. And to pin down this negligence thing, I noticed our material keeps mentioning four crucial elements.
Yeah, so to build a solid negligence claim, you need to tick four boxes. First, you've got to prove that the person who caused the harm owed you a duty of care.
So there has to be a legal obligation for them to act responsibly toward you in the first place.
Precisely. Then, you need to show that they breached that duty. They messed up, didn't live up to the standard of care that a reasonable person would have.
Failed to act reasonably. Okay, what's next?
Third, their failure to act reasonably directly caused your harm. You've got to draw that straight line, no detours between their actions and your injuries.
Cause and effect. And lastly,
You actually suffered some kind of loss. Could be physical injury, financial, emotional distress, something tangible because of their negligence. So it's not just enough for them to be a bit clumsy, it's got to have a real impact.
right, it can't just be theoretical harm. It's got to be real, measurable consequences.
Yeah.
Now, speaking of cases, there's one that keeps popping up everywhere in our sources, Donahue v. Stevenson. A case from 1932, apparently about a snail in a bottle of ginger beer. What makes that case so important in the grand scheme of things?
Donahue v. Stevenson is like the bedrock of modern negligence law, truly a landmark decision. You see, before this case, the idea of suing someone for negligence was much more limited.
So there were stricter conditions for who could sue whom.
Exactly. Often you could only sue if there was a pre-existing contract, like a direct agreement between you and the person who caused the harm. So let's say you bought a product directly from a manufacturer and it made you sick due to their negligence. Back then, you probably have a case. But if you bought that same dodgy product from a shop and it was the manufacturer who messed up, well, tough luck.
Wow. It sounds like 1932 was a real turning point in tort law. So Donahue v. Stevenson, decomposed snail and all, really changed the game.
Oh, absolutely. It established this crucial principle. You can be held responsible for your careless actions, even if you don't have a direct, contractual relationship with the person you harmed. It basically introduced the concept of a general duty of care that we all owe to our neighbors, legally speaking, of course. It's actually pretty mind-blowing to think that before 1932, your ability to seek compensation for someone else's negligence was so limited. It's amazing. Donahue v. Stevenson really did have a transformative impact, a huge impact on tort law as we know it.
Absolutely. It broadened the scope of responsibility, creating a much fairer system. Oh, and before we move on, just a quick side note for our international listeners. I saw that in Scotland, they actually call this whole thing delict instead of tort.
It's true. They've got their own unique legal lingo up there.
Always good to know. So to recap, tort law deals with the civil wrongs. Negligence is the kingpin, needing that duty of care, breach, cause, and damage link. And Donahue v. Stevenson, the snail in the bottle case, is like the big bang for how we understand negligence today. Let's zoom in on that first element, duty of care. What exactly does it mean to owe someone a duty of care?
Okay, so duty of care is the first hurdle in a negligence case. It basically acts as a gatekeeper, deciding whether someone's careless act will actually have legal consequences. It's a control mechanism, really. It's about establishing a legally recognized relationship where one person has a responsibility to act carefully towards another.
So you can't just sue anyone who's ever been a bit careless around you. There has to be this specific legal duty. Now, I see that in some situations, the law automatically recognizes this duty of care. Can you give us some examples?
Yes, there are certain relationships where the law says, look, we already know there's a duty of care here. Think about employer and employee, right? The employer's got a responsibility to make sure the workplace is safe for their employees. Same with teachers and their students, doctors and their patients, transport companies and their passengers, drivers on the road and pedestrians, manufacturers and consumers, just like in Donahue v. Stevenson. In these kinds of relationships, you don't have to go through the hoops of proving that a duty of care existed. It's a given.
That's logical. Makes sense to streamline things in these everyday situations. But what happens when it's not one of these well-established relationships? What if it's a brand new situation, a novel situation, and it's not so clear-cut whether a duty of care should exist? How does the legal system deal with that?
That's when it gets a bit more complex. But over time, the courts have come up with tests to help figure out whether a duty of care should be recognized in these novel situations. And the first big step came from, believe it or not, Donahue v. Stevenson itself.
The Snell case strikes again.
Right. In that case, Lord Atkin came up with this very famous neighbor principle or neighbor test. He basically said that we owe a duty of care to anyone who we can reasonably foresee might be harmed by our actions.
So it's all about foreseeability. If you can reasonably anticipate that your actions could hurt someone, even indirectly, then you have a duty to be careful.
Exactly. And this whole neighbor thing, well, it's not just about the people next door.
Yeah, I was going to say, it's not just about literal neighbors, is it?
Right. The legal neighbor could be anyone at all, who you should reasonably have in mind as being affected by what you do or don't do.
Okay, so it's much broader than just the people you share a fence with. It's about anyone who could foreseeably be impacted by your actions. But as thorough as it is, our material points out that even this neighbor test doesn't quite cover every tricky situation that pops up.
You're right. The law had to adapt, so the courts developed more tools for analyzing duty of care. That's where we get the three-stage Caparo test.
Right, from the case of Caparo, PLC v. Dickman in 1990. What are the three stages of this test?
All right. Stage 1. Was the harm reasonably foreseeable? We're borrowing that from the neighbor principle. Could a reasonable person have predicted that someone might get hurt because of the defendant's actions? Stage 2. Proximity. Was there a close enough connection, a close enough relationship between the parties involved? So it's not just like some distant butterfly effect. There needs to be a real link.
So the defendant's actions need to be a fairly direct cause of the harm, not some far-fetched chain of events. What's the third stage then?
Third stage. Is it fair, just, and reasonable to impose a duty of care in this particular situation? This is where the courts get to sort of weigh the bigger picture.
It sounds like they are considering the policy implications of their decision.
You got it. They're looking at, what impact will it have on society if they create a duty of care in this kind of situation. This three-stage test, the Caparo test, gives judges some flexibility, some room to maneuver when they're figuring out duty of care. It's not just a mechanical formula. There's room for judgment, for discretion.
It's about taking those broader implications into account, making sure it's a sensible decision. And our material also mentioned an incremental and analogical approach. What's that all about?
That's another way courts handle new situations. Basically, they look at past cases where duty of care has already been decided, and see if they can draw parallels with the case in front of them. They're looking for similarities, building upon existing legal principles rather than just, making up entirely new rules on the fly.
So they use precedent to guide their decisions, see if there's a match or at least a close resemblance to a previous case. It makes sense. Now, this next point surprised me. In tort law, generally, you are not liable for failing to act, for omissions, even if that leads to someone getting hurt. Can you explain that a bit?
Yeah, that's one of those principles that can seem a bit, counterintuitive at first. But the basic idea is that the law doesn't usually force us to be good Samaritans. You don't have a legal obligation to jump in and help someone, even if you could easily do it. And not helping might have bad consequences.
Okay, so let me get this straight. If I see someone, I don't know, struggling in a lake, and I'm a strong swimmer and could easily rescue them, but I just walk on by and they drown, I wouldn't be legally responsible.
In most cases, under English law, that's right. Of course, there are some important exceptions. For instance, as Lord Gough pointed out in Smith v. Littlewoods, if you've somehow taken on responsibility for someone's safety, like a lifeguard, or if you've created the dangerous situation yourself, then you might have a duty to act.
Ah, so it's not a completely free pass to ignore someone in need. There are some specific situations where a duty to act does kick in.
Right. So there are limits to this no duty for omissions rule. One is if you've kind of stepped into a role where you're expected to look out for someone, like a parent, teacher, or, as I said, a lifeguard. Another is if you have control over a third party who then causes the harm. Say you're responsible for a child who ends up hurting someone. And another important exception is if you create the source of danger even on your own property. Think a deep, unguarded hole in your garden where kids might be playing.
Makes sense. You can't just create hazards and then wash your hands of any responsibility.
And the last big exception to this omission rule is failing to remove a danger you know about, a known danger. Like if you're aware there's a loose railing on your balcony and someone could fall, you can't just ignore it.
Right. You've got to take reasonable steps to prevent foreseeable harm. It's interesting how we've seen this evolution of duty of care from a very narrow concept to these wider tests and exceptions, always trying to find that sweet spot between individual freedom and protecting people from harm. And I think that neighbor principle really sticks with you, doesn't it? The idea that your legal neighbor is anyone you could reasonably foresee being affected by your actions really drives home the potential scope of responsibility.
It certainly does. It emphasizes that our actions can have consequences beyond our immediate circle, a broader reach than we might initially realize.
Okay, we've laid the groundwork on duty of care. Next hurdle in a negligence claim is proving that there was a breach of that duty. What does that involve?
Okay, so we've established that a duty of care exists. Now we have to prove it was breached. A breach means the defendant didn't meet the required standard of care they owed to the claimant. It's about showing they acted in a way that a reasonably careful person in their shoes wouldn't have.
Right. So if a reasonable person would have foreseen the risk and taken steps to prevent the harm, and the defendant didn't, that's a breach.
You got it. And to figure out this reasonable person standard, we look to Blythe v. Birmingham Waterworks, a classic case. It's not about what this particular person thought was careful, but about what a hypothetical, average, reasonably careful person would have done. And keep in mind, this reasonable person isn't some super cautious, risk-averse individual. They're just, well, reasonable.
Okay. But how do you account for individual differences? Like, surely we don't expect a child to meet the same standard of care as a surgeon performing a complex operation.
You're right, and that's where the law makes some important distinctions. When it comes to kids, for example, they're judged by a different standard, the standard of a reasonable child of the same age. Mullen v. Richards is a good example here. Two 15-year-old girls were messing around with rulers, one snapped, and a fragment injured one of the girls' eyes. The court said, well, a reasonable 15-year-old wouldn't have foreseen that level of harm. They weren't negligent. It's also important to note that for children under 18, if they're being sued, they usually need a litigation friend, someone like a parent, to represent them in court.
Makes sense. You can't expect kids to have the same level of judgment as adults. Now, what about when we're dealing with, say, a doctor, a lawyer, or some other skilled professional? Are they held to a higher standard?
Absolutely. In those cases, the standard is that of a reasonably competent professional in that specific field. The Bolam test from Bolam v. Friend Hospital Management Committee comes into play here. Basically, a professional is not negligent if they acted in a way that a responsible body of medical opinion in their field would consider acceptable practice. It's not about finding the best practice, but one that is considered reasonable and responsible by their peers. However, it's important to note that the courts can still step in and reject expert opinion if it's completely illogical or flies in the face of basic common sense. The Bolitho case is a key example of this, where the court clarified that expert opinion is not automatically decisive. It's a really important check and balance in place. The Bolam test sets the bar, but the courts retain the power to make the final call.
Right. So just because some other professionals say it's okay doesn't automatically make it so. The courts still have the final say. What about on the flip side? Someone who is underskilled, for example, a learner driver. Are they held to a lower standard?
You'd think so, wouldn't you? But as a matter of policy, the law actually holds learner drivers to the same standard as fully qualified drivers. We see this in Nettleship v. Wester. This learner driver panicked, crashed, and injured their instructor. The court said, no, when you're behind the wheel, you've got to meet the standard of a competent driver, regardless of your actual experience. A lot of this comes down to insurance. All drivers on the road need to be covered, and holding them all to the same standard ensures everyone is equally protected.
That's a pretty tough standard for someone who's just starting out.
It is. It's basically saying, if you choose to engage in an activity that requires a certain skill level, you've got to be able to meet that standard.
Right. No excuses. Now, beyond these specific examples, what other factors do courts consider when figuring out if a breach of duty has occurred?
Well, our sources point to a number of important factors that come into play. First, there's the level of risk the defendant's activity created. So the higher the risk, the more care they're expected to take. Then there's the question of what precautions they could have reasonably taken, to prevent the harm. And this is where things get practical. The court will consider common practice in that particular field, the cost of safety measures, what knowledge about the risks existed at the time, and even the defendant's purpose for doing whatever they were doing.
Right. So it's a sort of balancing act, isn't it? Weighing the likelihood and severity of the potential harm against the burden and the expense of preventative measures.
Exactly. And let's not forget, it's the claimant who has to ultimately prove this breach actually happened. They have to show it's more likely than not that the defendant fell short of the required standard of care, usually through things like witness testimony, expert opinions, or documents.
So they need some solid evidence to back up their claim. And then there's that mysterious Latin phrase, res ipsa loquitur. The thing speaks for itself. What's that all about?
Res ipsa loquitur. That's a legal doctrine, a legal principle that comes in handy when it's pretty obvious something went wrong due to negligence, even if you don't have all the nitty-gritty details about how it happened. It's like the circumstances themselves are shouting negligence. Think of, a surgeon leaving a surgical tool inside a patient. That just doesn't happen without negligence somewhere along the line. The Southport Corps v. Esso Petroleum Co. Ltd. case is mentioned in our material, and while it wasn't a classic res ipsa scenario, it does deal with situations where the defendant was pretty much in control of events leading up to the harm. But to invoke this res ipsa loquitur magic, you need three things. First, the accident must be one that wouldn't normally happen without negligence. Second, the defendant must have been in control of whatever caused the accident. And third, there can't be any other plausible explanation. So it's a bit of a shortcut, a way for the claimant to establish a breach without having to prove every single detail of what the defendant did wrong.
Right. So the very fact that it happened is strong evidence of negligence. Interesting. We've covered duty of care and breach. Now we move on to showing that the breach actually led to the harm. That's where causation comes in.
Right. Causation, that's the link, the vital connection we have to establish between the defendant's screw-up and the damage the claimant suffered. And this causation thing, it's got two sides. First, we need to prove that the defendant's negligence was the actual cause of the harm. That's factual causation. And second, we have to show that the harm wasn't too remote, a consequence of the defendant's actions. That's legal causation.
Okay, two sides to the same coin. Let's start with factual causation. How do you prove that the defendant's actions really were the reason the claimant got hurt?
The cornerstone test for factual causation is the but-for test. The question is, would the claimant have suffered the harm but for the defendant's actions? The Barnett v. Chelsea and Kensington Hospital case shows this really clearly. A man goes to the hospital with horrible stomach pains after drinking tea that, unknown to him, had arsenic in it. The doctor on duty was negligent and didn't examine him. Tragically, the man dies. But later, expert evidence shows that even if the doctor had examined him properly, there was nothing they could have done to save him because of the amount of poison.
So even though the doctor was negligent, it didn't actually change the outcome.
Exactly. The hospital's negligence wasn't the factual cause of death. The man would have died anyway.
It's a stark reminder that negligence alone isn't enough. It has to be the decisive factor in the harm.
Right. And when it comes to proving factual causation, our sources mention this all-or-nothing approach, which was really prominent in Houghton v. East Berkshire Area Health Authority. In essence, the claimant has to show that it's more likely than not the defendant's negligence was the cause, more than a 50% chance. In Hodson, a young boy fell and injured his hip. There were delays in treatment, and his condition worsened. He sued the hospital, but he couldn't prove that the delay was more likely than not the reason he developed a disability. There was already a chance he'd be disabled because of the initial fall, and the delay only increased that chance. Because it wasn't more than a 50% chance, he didn't get full compensation.
Wow, so even if negligence significantly increases the risk of harm, it might not be enough for full compensation if the harm was already somewhat likely to occur anyway?
That's the general principle in these all-or-nothing cases. But there are exceptions, like the material contribution approach in Bonington Castings v. Wardlaw. This case dealt with a guy who developed a lung disease from inhaling dust at work. There were two sources of dust, one negligent, one not. He couldn't prove which dust caused his illness, but the court said, well, the negligent dust exposure definitely increased his risk of getting the disease, so the employer was liable, even if their negligence wasn't the sole cause.
So if negligence tips the scales toward harm, even if there are other factors at play, that can be enough.
Precisely. It's about making a difference to the outcome, materially contributing.
Okay, and what about these terms I keep seeing, divisible versus indivisible injuries? What's the importance of that distinction?
This distinction is crucial when figuring out who pays what, particularly when you have multiple people contributing to the harm. So, indivisible injuries, like asbestosis, are those where the damage is a single unified result, difficult to separate into parts caused by different sources. In Holt v. Brigham Cowan, Hull, Ltd., a worker got asbestosis after being exposed to asbestos dust at different jobs. The court said, well, you can't really divide up the harm neatly, so any employer whose negligence contributed can be held liable for the whole thing. They can then try to sort it out amongst themselves and get contributions from each other.
Ah, so it's about simplifying things when the harm can't be neatly apportioned.
Exactly. Now, divisible injuries are different. These are harms that can be separated out, attributed to specific events or people. For example, let's say you're in a car accident and break a leg, and then later you're in another accident and injure your arm. Those are divisible. You can trace each injury back to a distinct event.
Okay, clear enough. Now let's talk about something that sounds a bit like a legal plot twist, novus actus interveniens.
Ah, yes. Novus actus interveniens, Latin for a new intervening act. It's a bit of a mouthful, but it's essentially about a subsequent independent event that breaks the chain of causation between the defendant's negligence and the ultimate harm. If this novus actus thing happens, the original wrongdoer might get off the hook. A classic case that illustrates this is Scott v. Shepard. A guy throws a lit firecracker into a crowded marketplace. It gets tossed around by a few people instinctively trying to protect themselves before it explodes and injures someone. The court said, look, those people who threw the firecracker on weren't making free choices. They were reacting instinctively, so they didn't break the chain of causation. The fault still lay with the original thrower.
Wow, talk about a chain reaction. So if someone's negligent action set off a series of events, but then something completely unpredictable happens, like an act of God or some third party's deliberate wrongdoing, that could break the chain.
Exactly. The original negligence might still be a factor, but it might not be the legal cause of the final harm. A good example of this is Roberts and Anor v. Bettany and Anor, where a negligent act by a third party was considered to have broken the chain of causation. The original negligence might create the circumstances, but it's that new independent act that's the real culprit. And the key here is foreseeability. If the intervening act was something completely out of left field, something that no one could have reasonably anticipated, it's more likely to break the chain.
Okay, so if I carelessly spill some water on the floor, and someone slips and falls, but then while they're lying there injured, a meteor crashes through the roof and lands on them.
That's a very unlucky situation. But yeah, the meteor would likely be seen as a novus actus interveniens, breaking the chain of causation from your initial negligence.
Yeah, makes sense. All right, so we've proven factual causation. Now, what about remoteness of loss, the legal causation aspect?
Remoteness basically asks, was the type of damage that occurred reasonably foreseeable at the time of the defendant's negligence? Overseas Tank Ship, UK, Ltd v. Mort's Dock and Engineering Co. Ltd, or Wagon Mound No. 1, as it's often called, really cemented this principle. In this case, a ship negligently spilled oil into Sydney Harbor. However, a few days later, the oil caught fire, causing a massive blaze and extensive damage. The court said, look, the initial oily mess, that was foreseeable. But no one could have predicted that a fire would break out. The fire damage was too remote a consequence, so the ship owners weren't liable for the fire damage.
So it's not just about whether your actions did cause the harm, but whether that specific type of harm was a reasonably foreseeable consequence.
You got it. Foreseeability is key here. If the harm was so unlikely, so outlandish that no reasonable person would have anticipated it, the defendant might not be on the hook for it. Okay, so we've got causation sorted, factual and legal. Now, what happens when a claimant successfully proves their case? What kind of remedies can they expect?
Right. What can the court actually do to right this wrong?
Well, the primary goal of remedies in tort law is to compensate the claimant, to try and put them back in the position they'd be in if the tort never happened. This is where damages come in, and we're talking about money here, compensation for all sorts of things, past and future earnings they've lost, medical bills, the pain and suffering they've endured. It's usually a one-time payment. But here's the catch. The claimant has a duty to mitigate their loss.
So they can't just sit back and let the damages pile up if there are things they could reasonably do to reduce them.
Exactly. They've got to be proactive. And generally, you only get one shot at claiming damages for a particular incident. You can't keep going back for more if it turns out worse than you initially thought.
Okay, one claim per set of facts. Makes sense. And our sources distinguish between general damages and special damages. What's the difference there?
Special damages are the ones you can calculate precisely, like lost wages up to the trial, receipts for medical expenses. It's all about the cold, hard figures. General damages are the trickier ones. These are for things like pain and suffering, loss of enjoyment of life, or future financial losses, stuff that's harder to put a precise price tag on. It involves more estimation.
Right, so special damages are concrete, and general damages are more, well, subjective.
Precisely. And when we're talking specifically about personal injury cases, we often divide damages into pecuniary losses, which are the financial ones, like lost income or medical costs, and non-pecuniary losses, which are the less tangible ones, like pain, suffering, and the impact on your quality of life. And a really important principle to remember here is the eggshell skull rule.
Ah, yes, take your victim as you find them.
Exactly. It means if you negligently cause a foreseeable type of injury to someone, you're responsible for the full extent of the harm they suffer, even if they have some pre-existing condition that makes them more vulnerable. Page v. Smith is a classic example. In this case, a guy was in a minor car accident, no physical injuries. However, the accident triggered a chronic fatigue syndrome he had, leading to long-term disability. The court said, well, some personal injury, even if minor, was foreseeable in a car accident. So the defendant was liable for the full extent of the chronic fatigue, even though someone else might have just walked away with a few bruises.
So you can't use the excuse that, well, they were already a bit fragile, so it's not really my fault they got so badly hurt.
Right. You take your victim as you find them, vulnerabilities and all. Now let's switch gears and talk about pure economic loss, which our sources treat separately from physical harm. What's the key difference between this and, say, the financial losses someone might experience after a physical injury?
Well, in tort law, we often break down losses into three main categories. First off, you have physical damage. This is the most straightforward. Someone's property gets damaged or they sustain a physical injury. Then you've got what's called consequential economic loss. That's financial loss that directly flows from the physical damage. For instance, if you break your leg in a slip and fall accident and can't work, your lost wages would be consequential economic loss. And then there's pure economic loss. This is where you suffer financially, but there's no physical damage to you or your property involved.
So it's like a ripple effect, but with no initial physical splash.
Right. And the general rule in tort law is that pure economic loss is not recoverable. This is largely due to policy concerns, a fear of opening the floodgates to potentially limitless claims. It sounds like the courts are worried about chaos. Everyone suing everyone for every financial setback.
Yeah, the Spartan Steel case, Spartan Steel v. Martin, illustrates this really well. So a power cable gets negligently cut, causing a power outage to a steel factory. They had a batch of steel in their furnace that got damaged because of the power cut, plus they lost profits from that batch and from future batches they couldn't make because of the outage. The court said, okay, you can claim for the damaged steel and the profits you lost on that batch because those are directly tied to the physical damage. But the lost profits from future batches, that's pure economic loss. Too far removed, no dice.
So if a power outage affects a whole street, businesses lose money, they can't all sue the power company unless they had physical damage to their specific property.
Generally, that's right. There needs to be a more direct link than just financial disappointment.
Makes sense.
Yeah.
But of course, there are exceptions. Our sources do mention specific situations where you can recover for pure economic loss.
Right. There are a few carefully carved out exceptions. One area where you might think you could recover is for financial losses when you buy a defective product. But Murphy v. Brentwood District Council clarified that this usually isn't possible. You can't claim a negligence for, say, a house that's defective and loses value. The House of Lords essentially said that's what contract law and building regulations are for, not tort law.
It seems a bit rough on someone who buys a lemon, but I guess the courts are trying to keep things contained.
Exactly. And another instance where you might think you have a case is if someone else's property gets damaged and that indirectly causes you to lose money. But Spartan Steel, the power cable case, shows This usually doesn't fly either. The damage has to be to your property.
So my supplier's factory burns down, my business suffers, but I can't sue whoever caused the fire.
Generally not, unless you have a direct contractual relationship with them or suffered direct damage yourself. There has to be that close connection.
Okay. But a big exception where pure economic loss is recoverable is when it's caused by negligent advice or statements.
Yes, this is a key one. Hedley Byrne v. Heller and Partners is the game changer here. It's about situations where someone relies on professional advice and it turns out to be bad advice. The court said, look, if there's a special relationship, like a financial advisor giving advice to a client, and the advisor takes on responsibility for their advice, and the client reasonably relies on that advice and loses money, well, then the advisor can be liable for that pure economic loss. So there needs to be that trust, that assumption of responsibility, and that reasonable reliance for this too.